Hello, my name is Marcia Shimizi. Thank you for joining our studio audience here at Robert Morris University in the Academic Media Center for the second show in our four-part series of the First Amendment on Trial. I represent Monument Agency, a class-created public relations firm in the social media and public relations class. Myself and my teammates, Kayla Peebles, Jocelyn Burns, Chase Lang, and Amy Gamir, have been learning how to develop a social media campaign since August. We're all about experimental learning here at RMU, and a special feature of this program is we have students from 4 high schools in our audience. We have Cornell High School, Weir High School, Propel High School, and PA Cyber high school students are joining us via Facebook. The First Amendment on Trial, Freedom of Speech, was made possible by a grant from Free Speech Center at Middle Tennessee State University. Professor Ann Summerall-Jabro and David Jameson were awarded the grant for designing an inclusive experiential learning experience, or learning by doing. That involves 3 academic units at Robert Morris University: Communication, Political Science, and Academic Media Center. We're all about intellectual experiences at RMU, and this one includes our audience too. There are no winners or losers from this experience because we all learn something instrumental about our disciplines in real time. And you're learning to listen effectively, think critically, and render a judgment on the quality of the arguments presented. At the conclusion of the show, you'll be asked to vote for the debater that presented the most compelling case. Thank you for joining us today and listening intently to the arguments presented. And now I would like to present Professor David Jameson, and he's going to introduce the debate.
Thank you and welcome to everyone, to our studio audience, to those joining us via live stream, and especially to the high school students who are joining us for today's experience. As you have a chance to see Robert Morris University students debating some of the most significant issues of our time. This series is called the First Amendment on Trial, and throughout this series of 4 programs, we will have an opportunity to explore in depth some of the most important personal freedoms that we as Americans enjoy, the freedoms guaranteed by the First Amendment to the Constitution. Freedom of religion, freedom of speech, freedom of the press, and freedom of assembly and petition. To help us understand these freedoms, Robert Morris University political science students have researched significant cases from U.S. Supreme Court history. In these programs, you will hear our students present the arguments to the court in cases testing First Amendment limits. As in a real Supreme Court appeal, each advocate will argue their client's position and then be available for a rebuttal of the other advocate's position. Today's First Amendment topic is freedom of speech. One important testing ground for how far freedom of speech extends has been in public schools. Today, 2 student advocates will argue the case that presents the question of high school students' freedom of expression, balanced against the right of teachers and fellow students to focus on the school's educational mission. Our advocates for this case are Kristen Davis and Rachel Pracht. Kristen and Rachel are both sophomores at Robert Morris University, both majoring in political science. Representing the judiciary as our presiding judge is the Honorable Justin P. DePlato, Professor of Political Science. All rise. Judge DePlato.
Good afternoon. You may be seated. I will remind those in the gallery to please remain quiet during oral argument. I will now hear case number 19-212, Deborah Morse, petitioner versus Joseph Frederick, respondent. Counsel, please enter your appearances.
Kristen Davis, Your Honor, representing Deborah Morse and Juneau Douglas High School.
Rachel Proctor, Your Honor, representing Joseph Frederick.
Thank you. I will remind counsel that each of you will have 15 minutes for oral argument and 5 minutes for rebuttal. Ms. Davis, please proceed.
May it please the court. Illegal drugs and the glorification of drug culture in America are profoundly serious issues plaguing our nation. Even more serious is when the promotion of drug culture interferes with the education of America's students in our public schools. On January 24th, 2002, Deborah Morse, principal of Juneau Douglas High School in Juneau, Alaska, disciplined student Joseph Frederick for a violation of school policy regarding the promotion of drugs and drug paraphernalia. On that day, the Olympic torch for the 2002 Olympics in Salt Lake City, Utah, was passing through Juneau, and the school determined that they should grant their students the privilege to see such a historic event during their regular school day. Mr. Frederick decided to spit in the face of that privilege by unfurling a banner with the phrase, "Bong hits for Jesus." This was in order to attract the news cameras at the event and gain notoriety for himself. When Miss Morse saw the choice he had made, she immediately seized the banner in order to protect both the sanctity of the event and preserve the order of the academic environment that existed, despite the event not actually taking place on school grounds. Being that the sign made a clear reference to drug use and paraphernalia, she confiscated the banner in compliance with the Juneau Douglas High School policy that was anti-drug and continues to be enforced throughout the district. Because of Mr. Frederick's violation, she was obligated to suspend him for 5 days, but later made the decision to increase the suspension on the basis of insubordination. Her decision to do so was later upheld by both the superintendent and the school board, and the process was fully decided by March 19th, 2002. When Mr. Frederick's appeal was brought to the United States District Court for the District of Alaska, they sided with the school and Ms. Morse on the basis that they did not infringe upon his First Amendment rights in their attempts to protect both the student body and the associated academic environment. The decision was made summarily and echoed the precedent set by Bethel School District number 403, First Fraser. That decision, made by this court, governed school speech and established that schools are able to regulate speech they deem as vulgar and or offensive. Based on the messaging on the banner in Mr. Frederick's possession, she reasonably interpreted it to be in violation of the Juneau Douglas High School policy on drug abuse prevention. Unfortunately, the U.S. Court of Appeals for the Ninth Circuit felt that her punishment was made in order to suppress Mr. Frederick's First Amendment rights and censor him for promoting a social message contrary to the school's preference. On the contrary, her decision was made for the protection of the student body on the basis of drug abuse prevention and to maintain a standard for discipline and reasonable expectations of student behavior during school-authorized activities. Due to the decision of the U.S. Court of Appeals for the Ninth Circuit, we felt compelled to submit a writ of certiorari to this court, and we appreciate the Supreme Court's interest in hearing our appeal. The precedent set in the case Tinker v. Des Moines Independent Community School District is that there is a right to political speech that could be disruptive, but not a right for that speech to actually be disruptive. The disruptiveness in this case is behavior detrimental to the educational mission of Juneau Douglas High School, in a violation of the school's announced policy to enforce and support laws with respect to the control of marijuana and other laws related to drug abuse in general. In Tinker, there was no written policy. It was an issue of standardless discretion being exercised. That case was said to be concerned with school disciplinary actions, casting a pall of orthodoxy to prevent the discussion of ideas. In the case of Tinker, students were granted the right to free speech on the basis that it would be non-disruptive, as in wearing armbands, and not seen as being connected with the school. Mr. Frederick's speech, the displaying of the banner at a school-sanctioned event, was clearly disruptive to the student body and could have been connected with the school because it was shown on television as part of that same school-sanctioned activity. As noted previously, the case of Bethel School District v. Fraser provides an important precedent in considering the right of Ms. Morse to discipline Mr. Frederick. In that case, this court determined that schools have the right to prohibit vulgar and offensive language, which we believe the phrase "bong hits for Jesus" qualifies as. Such discourse is inconsistent with the mission of both Juneau Douglas High School and public schools on the whole. It is not political speech expressing a particular idea. It is merely an attempt to attract attention to oneself and disrupt an effort made in good faith to expose our students to history as part of their education. The penalties imposed upon Mr. Frederick were a result of the disruption he intended and did develop, not any political views he claims to have been advancing. Additionally, the case Hazelwood v. Kohlmeyer demonstrates that school-sponsored activities are not normally protected from administrative censorship under the First Amendment. In this context, the viewing of the torch passing was not intended to be a public forum, and as such, the school and Ms. Morse had the ability to exercise control over student speech at this school-sanctioned function because it related to a legitimate pedagogical concern. It stipulated that school administrators are not required to tolerate speech that is contrary to our academic mission and or interferes with the requirements of school discipline, interferes with student rights, interferes with academic propriety, generates health or welfare concerns, or is deemed obscene or vulgar. The First Amendment did not require schools to affirmatively promote particular types of student speech. And the court held in Hazelwood v. Kohlmeyer that schools must be able to set high standards for student speech that is disseminated under their supervision, and that schools retain the right to refuse to sponsor speech that is inconsistent with the shared values of a civilized social order. The key here is that school officials must be able to reasonably interpret messages and react accordingly, so long as that interpretation is reasonable, which it was in this instance. The First Amendment does not require public school officials to stand aside and permit students who are entrusted to their supervision and care to promote or encourage the illegal use of drugs. Again, Hazelwood v. Kohlmeyer demonstrates school administrators are empowered to regulate student speech in the context of school-sponsored activities because they have the obligation to promote the school's academic mission and serve the values of social order and consistency in the setting of public education. This can also be seen through the decision in Board of Education v. Earls, which establishes the ability of public schools to promote anti-drug policies through a variety of actions, because the school district has an important interest in detecting and preventing drug use among its students. As such, Ms. Morse had the obligation to take Mr. Frederick's banner, which promoted drug use, in order to abide by Juneau Douglas High School's established drug abuse prevention policies. So in conclusion, the court should uphold Ms. Morse's actions on the basis that she was protecting the academic policy by following established written policy on drug abuse prevention. This action is in accordance with precedents set by Tinker v. Des Moines, Hazelwood v. Kohlmeyer, Bethel School District v. Frazier, and Board of Education v. Earls. Without enforcing standards that allow school administrators to protect the student body and preserve the academic environment, there's an inconsistency that develops that could create significant disruptions and promote to students that vulgar ideas, such as drug use, are permissible and do so with the endorsement of the nation's highest court. Thank you, Your Honor.
Thank you, Counselor. I have a question for you. Let's assume for a moment the sign did not read, quote, "bong hits for Jesus." Rather, the sign read, "glaciers are melting." Would the court still have permission to restrain appellate's First Amendment free speech protections?
I believe the concern here is that the message on the sign was in violation of the anti-drug policies, and I don't believe that Ms. Morse would have reacted in the same way if had there been a different message, unless it was seen to be as disruptive as this one was.
Thank you very much, Counselor.
Thank you, Your Honor.
Ms. Prack, please proceed for the respondent.
May it please the court. This case is not about drugs. This case is about the free speech of a student, not the advocacy of drug use. This was a content-based striking of student speech and thus must be regarded from a strict scrutiny standpoint. The school must provide compelling interest in its deprivation of Mr. Frederick's rights. It must also prove that it used the least restrictive means in the process, neither of which was done. Mr. Frederick's banner was displayed off school property. While the school sanctioned the students leaving class to view the Olympic torch event, the event itself was not school-sponsored. If the event was not sponsored by the school, how can the administration attempt to regulate a student's speech at the event? Mr. Frederick was not acting in the capacity of a student at the time in question. He was a teenager awaiting the passing of the Olympic torch. With this distinction in mind, how can a school punish an ordinary citizen for actions outside of school property? Mr. Frederick had not attended his morning classes and so had not been dismissed alongside his classmates. He stated on record that he had gone to the spot not in order to meet up with other classmates, but to be in a place that he could be certain the torch passed because, as stated, his intention was to get on TV. The intention of the dismissal was for students to watch the event, yes, but many did not. There was no real obligation to attend, and that's contrary to the claim that it was a school-sponsored event, subject to the same rules regarding behavior as an assembly or a field trip. Teachers were outside and intermixed with the crowd, but there was no strict supervision of students on their part. And not only teachers, but non-students who were completely unaffiliated with the school were in attendance as well. In addition to being expressed off of school property, the school didn't provide any compelling evidence of a substantial disruption caused by Mr. Frederick's banner or the views expressed therein. Under Tinker, such a disturbance to the educational mission is required to regulate the speech of a student. The Supreme Court made it clear that students do not leave their constitutional rights at the door when they enter school property. In this case, Mr. Frederick was not even on school property at the time when his sign was displayed. The banner was held up on a sidewalk, awaiting the cameras to pass by, not in a classroom or obscuring anyone's views of educational materials. Additionally, there's no grounding for an argument that the banner could tarnish the school's image. It was held up across the street, so it would not be pictured with the school or associated with the school at all. Just the presence of Mr. Frederick holding the sign would not be enough to connect it to the school either, as he would not be known by most people to be a student of that specific school. So what disturbance to school activities was caused by the banner, aside from that caused by Ms. Morse when she approached Mr. Frederick and insisted he take down his banner? The banner itself was not offensive as outlined under Fraser. The phrase itself is not lewd or with any vulgar underpinnings. The banner did not evoke inappropriate behavior or obscene language from the other students and onlookers. Without any direct messages of that nature, and taking into account the fact that there's no evidence of it negatively affecting the crowd, what authority would a school administrator have to force the removal of the banner? It was only Ms. Morse's interpretation of the banner that caused any sort of commotion. As a matter of fact, misinterpretation may be better phraseology. What kind of message was Mr. Frederick's banner really sending? Bong hits for Jesus. Is it really promoting drug use? Not really. Is it nonsensical? Yes. Is it provocative? Of course. But is it meaningful? Definitely not. It's nothing more than a ridiculous phrase written by a teenager looking for attention. It doesn't encourage others to use drugs. It doesn't proclaim the benefits of drugs or of drug use. It doesn't paint drugs in a positive light. Really, it says nothing at all about drugs or about anything. It simply uses a phrase for shock value in order to get on television. Any perceived advocacy of drugs is on the side of the viewer. While it generally is a school administrator's job to make sure student behavior adheres to school policy, completely entrusting interpretation to administrators leaves too much room for the interference of personal bias. Interpreting the phrase, bong hits for Jesus, as encouraging the use of illegal drugs is not reasonable, as it doesn't actually say to use drugs or give any positive endorsement of drugs. It was Ms. Morse's own personal position on marijuana that led to her interpretation of the banner. It may be excusable that in the heat of the moment she would go over and address the banner's message with Mr. Frederick, but after hearing his reasoning and intentions, she should have walked away from the situation instead of pursuing punishment. Assuming for a moment, then, that the petitioner's position on the matter is correct, and there is some sort of advocacy for the use of marijuana, would it not still be protected speech? The court determined in the Tinker case that non-disruptive expressions of a student's political views are fully within their First Amendment rights. Wouldn't Mr. Frederick's banner qualify as a political statement if it were interpreted as support for the movement to legalize marijuana? With such vague language, there could be any number of interpretations as to the meaning of it. In fact, moving away from the marijuana aspect, the First Amendment also protects the right to freedom of religion. So long as we're convinced there's some sort of coherent meaning behind the banner's phrase, the use of the name of Jesus could be interpreted as having religious significance. If the banner has both political and religious implications, it should be doubly protected under the First Amendment. Again, assuming that the petitioner's assertion that the reasoning behind the banner is to promote the use of marijuana, there are still questions to be raised. Based on Brandenburg, punishment for encouraging illegal activities, such as drug use, is to be based on the likelihood of the statement to incite the illegal behavior that is attempted to be avoided. To make sure the school's punishment of Mr. Frederick is permissible, it would need to provide evidence that the banner directly caused other students to use marijuana. the probability of Mr. Frederick's banner having such an impact is unlikely. With such a nonsensical and ambiguous phrase, it's impossible to determine from the words themselves what exactly the intention of the speech is, let alone to declare without a doubt that its intention was to promote the use of marijuana. As I mentioned earlier, it is also the responsibility of the school to prove that it enacted the least restrictive means in dealing with Mr. Frederick. The punishment of 10 days of out-of-school suspension, not including the scene caused by Ms. Morse on the day the event took place, cannot be considered least restrictive means. Such a penalty for the so-called offense of holding up a sign with an absurd and ambiguous phrase cannot be considered reasonable. Freedom of speech is our most important First Amendment right because the other protections of the amendment are dependent upon it. It must be defended at all costs, especially in relation to younger generations who we rely on to carry such ideals into the future. Thank you.
Thank you, Counselor. I have one question for you. If we consider for a moment the illegality and illicit nature of the banner, which is supporting drug use, then how might we apply the Fraser ruling? Further, should the court agree that the student's liberty must be restrained in the public school setting, which includes proximity to a school, such as in this case with the banner across the street?
The first issue is assuming that the interpretation of the banner is correct. This Fraser ruling would require that the interpretation of the banner is that it's promoting the use of marijuana. In this case, all it said was bong hits for Jesus. It uses slang for an illegal drug term, but it doesn't promote the use, it doesn't advocate using marijuana, it doesn't say anything about that. In the Fraser case, the student made purposely inflammatory remarks to incite excitement in the crowd. So in this case, Mr. Frederick just wanted to get on TV. He had no intentions of causing any disruptions. So with that, I think that the proximity to the school could be considered an issue, but he was not shown next to the school or really connected to the school in any way.
Thank you, Counselor. Ms. Davis, you have 5 minutes for rebuttal.
Thank you, Your Honor. So on Ms. Prock's first point of assuming that Mr. Frederick was not affiliated with the school, I don't think that's a fair interpretation of what happened. Being that Mr. Frederick was a teenage boy who was out at a public event during regular school hours, it would be the reasonable assumption of anyone to assume that he was a student at Juneau Douglas High School. And as such, whether or not he was actually at the school or standing in front of the school with this banner, his actions can still be affiliated with the school district of Juneau Douglas High School. And so on that point, it's important to recognize that when he upheld this banner, he was representing Juneau Douglas High School, whether he intended to or not. And as such, Ms. Morse had the obligation to enforce school policy and discourage drug promotion. Again, in the terms of how we interpret the message of bong hits for Jesus, how can we really be sure that this isn't lewd? What else could bong hits for Jesus really be alluding to other than drug use? It's a slang term, yes, but it's a slang term that typically only has one meaning. And so in that sense, we have to, again, act on what we know. We know what bong hits for Jesus refers to, and we have to ensure that there is a standard for discipline for all students in the district to follow. If there's an exception made for Mr. Frederick just because he was trying to get on television, what other exceptions could be brought forth by other students who claim they weren't actually trying to promote drug use, they just wanted attention? How can we draw that line if we make the exception here? As I stated previously in my initial argument, Hazelwood v. Kuhlmeyer is one of the most critical cases to look at for precedent. It stipulated that school administrators are not obligated to tolerate speech that is contrary to the academic mission of the school. Bong Hits for Jesus isn't promoting a sound academic environment, and Ms. Morse had, again, the obligation to take down that sign and promote a safer academic environment, being that viewing the torch passing was a school-sanctioned activity. She didn't have to allow for the promotion of speech that interfered with requirements of school discipline or interfered with academic propriety or generate health or welfare concerns, all of which Bong Hits for Jesus violates. So as such, I believe that the court should uphold Ms. Morse's decision to infringe upon what Mr. Frederick views as his own First Amendment rights, because the promotion of drugs is utterly inconsistent with what the educational mission of Juneau Douglas High School is. The court has spoken broadly with respect to deferring to school officials and identifying what that mission is. And while students have rights which were outlined in Tinker, it's important that school officials are given the ability to make decisions for the betterment of the entire student body, rather than attempting to make exceptions for what students claim they were trying to do. Thank you, Your Honor.
Thank you, Counselor. Ms. Prack, you have 5 minutes for your rebuttal.
So in my rebuttal, I would like to, again, just underline how important it is that the intention and the interpretation of the speech is considered. The intention of Mr. Frederick's banner had nothing to do with promoting drug use or encouraging any of his classmates to do drugs. And the interpretation that he did mean that is all based on what the viewer thought. So Ms. Morse's interpretation, yes, did mean that she saw it as contrary to what the school's promotion is. The schools obviously have the right to discourage the use of illegal drugs, but how can a school regulate what something that someone said that does not actually have any serious implications of drug use? It was slang, and it was not directly encouraging anyone to do drugs. And as for his connection to the school, yes, maybe local people would know that he's from the school, or someone who knew that that school was there right next to where the torch was going past. But on the larger scale of anyone who would be viewing the video of him in it with his sign, largely it would not be conceived as something that would be connected to the school in any way. So the question we debate today is an important one. If students go through their formative years in the school system without experiencing a protection of their First Amendment right to free speech, what kind of expectations will they carry out into society? How can our country further its tradition of freedom of speech if we teach children not to expect it? The United States was founded on this freedom, and to take it away from young people is to remove it from the future. Without the right to free speech, so many of our other rights become meaningless. What is our right to religious freedom if we can't speak about our faith? What is our right to freedom of assembly if we can't discuss anything when we assemble? What is our right to vote if we can't express and discuss our opinions on candidates and policies? If we can't get truthful information from the media and we have to rely on propaganda? Mr. Frederick should not have been punished for his banner, not only for a fair outcome in this case, but to carry on the legacies of the right of the First Amendment in the future.
Thank you, Counselor. Ladies and gentlemen, we have heard the arguments for both sides of this important question. I now ask that those in the gallery and participating via simulcast to cast their ballots for which advocate presented the more compelling argument. As you vote, let me reflect on the importance of a case like this one and on the quality of the arguments presented by our student advocates. The question of balancing free speech with the school's intent to protect students from harm, and in this case the harm is the endorsement of marijuana, is very important. The court has spoken often on the limits of free speech in Brandenburg and Scheck and so on, and the court acknowledges at times the need to prohibit speech that inflames conflict, the so-called harm test. The court has even gone so far to limit speech it deems as fighting words, as it did in Chaplinsky. The court should never take limiting free speech for any reason without great scrutiny and prudence. The right of speech, as you've mentioned, is a bedrock to liberty, supporting and reaffirming the other sacred liberties. We should always hold free speech as sacred, and as Justice Cardozo thought, quote, first among the order of our liberties. Any limit of speech must meet the highest standards as set forth by this court. Petitioners have given us two solid arguments for and against the students' free speech. The speech here is advocating for a potential harmful use of an explicit drug. The use of marijuana, although gaining acceptance as a recreational drug, is still in fact a felony under present law. though I suspect saying beers for Jesus or the glaciers are melting would be thought of differently, potentially political speech. For this reason, I find the matter before us so deliciously puzzling. I think of Orwell when he said, quote, "If liberty means anything at all, it means the right to tell people what they do not want to hear." Further, I suspect the student is satirically endorsing the use of a drug, and paradoxically, this drug is widely used, and possibly even by the teachers that find the need to restrain its use. How and why, then, should the court place limits on such speech? Are we so naive to think that adolescent students are not smoking marijuana and likely find the sign provocative, which was its intent? This provocation has led to us talking here today, and isn't that a good thing? So in the opinion of this humble judge, there is little to no basis for harm, and for this reason I grant free speech protection in favor of Frederick. And now I welcome back our student host to announce the results of the vote.
Thank you, Your Honor. Really quick before we go to any type of break, I do want to say congratulations to both debaters. You guys did so amazing and really represented your cases really well. Okay. So while we're waiting for the results, I do want to say a quick shout out to a couple people who have helped us through this process, especially planning and executing. So I'd like to thank all of the staff of the Academic Media Center, everybody who has put themselves involved and has really helped us through the process. It's been a really exciting experience, and I'm very thankful for it.
Join us in the Academic Media Center for the First Amendment on Trial debate series every Thursday until November 21st at 1:30 p.m.
Are you aware of all 4 parts of the First Amendment?
I thought it was just the freedom of speech.
Do you exercise your First Amendment rights?
I don't know what they are.
Do you think it's important to have a good understanding of your First Amendment rights?
Yeah, of course.
Do you know all 4 parts of the First Amendment?
No, actually I don't.
A big shout out again to our student debaters who spent countless hours researching and writing their cases and presenting them for us today. Our audience members have listened attentively, and they have selected Rachel Pracht for the most effective case. At the conclusion of so sorry. We appreciate everybody coming out today, and we tried our best to focus on making people aware of their First Amendment rights. That was the goal of this whole campaign. So we would love for everybody who's involved in our audience and on our Facebook Live to post their comments about the debate and our public relation efforts on the Facebook page, First Amendment on Trial. And don't forget to join us next week for our next debate. Same time, same place. Thank you, everybody. Yeah?